If someone's living in your house right now and won't leave, do not change the locks. Don't shut off the power and don't just start hauling their stuff to the curb. That one move, the one that feels obvious, is often illegal, and it can flip you from the victim into the defendant. Here's the strange truth about squatters. Once someone's set up residence, even unlawfully, the law usually treats getting them out like a legal process, not a home improvement project. So in this video, we'll walk the whole thing. How a squatter is actually different from a trespasser or a tenant. The real legal path to get them out: document, notice, court, sheriff. Exactly which do-it-yourself moves backfire and expose you to liability. How to stop the adverse possession clock before it starts running against you. Real examples of how fast some states are moving to fix this, and when it's time to stop and call a lawyer. This table is the whole ballgame, so look closely at that middle column. A trespasser, someone who wandered onto your porch or your yard with no intent to live there. You can usually just call the police, and they'll remove that person on the spot, because it's straightforward criminal trespass. But the moment somebody moves belongings in, starts sleeping there, maybe even gets mail delivered, courts, and more importantly, the sheriff's department start treating that like a housing dispute, not a trespass call, even though the person never had permission and never signed anything. That's the part that stuns homeowners. A stranger sleeping in your guest room for one night is a trespasser you can get removed same day. The same stranger, 2 weeks later, having set up a bed and a mailbox, has often crossed into squatter. And that one difference determines whether you can call 911 or whether you have to go to court. So what actually flips the switch? There's no nationwide bright line, but the pattern courts and police look for is genuine occupancy. Did this person move furniture in? Are they sleeping there night after night? Is there any paper trail treating the place as their address? Florida's new squatter law actually spells this out as a checklist. No utility bills in their name, no government records at that address, minimal or no rent paid, are red flags that someone isn't legitimately housed there, which is exactly why owners are told to gather that evidence fast. And here's the part that should genuinely worry you. Some squatters know this and race to fake it. A forged lease, a utility bill they talk someone into switching into their name, because the more legitimate they look on paper, the slower and messier it gets for you. That's why the first 48 hours after you discover them matter enormously. This flowchart is the legal spine of the whole video, so slow down on it. Step 1 is boring, but it's everything. Photograph the person's belongings, the dates, anything proving you never gave permission. That file is what every later step leans on. Step 2, you serve a proper written notice, and the exact form and the number of days depends entirely on your state. So this is not a fill-in-the-blank you print off the internet and trust blindly. If they still won't leave, step 3 is where most homeowners are surprised. You file in civil court, and depending on your state and whether this person was ever technically a tenant, that's either an unlawful detainer action or something called an ejectment lawsuit. Win that, and step 4 gets you a writ of possession, a piece of paper, not a key. Step 5 is the one people blow past. That writ doesn't authorize you to go change the locks. It authorizes the sheriff or a marshal to physically remove the person. You can't skip to the end and do it yourself, even with a court order sitting in your hand. I keep saying varies by state because it genuinely does, more than almost anything else in homeowner law. Some states let you move to an expedited affidavit process for a true stranger with zero tenancy claim. Others still expect a more traditional notice and file process, even for someone who was never your tenant. The unlawful detainer route tends to move faster because courts run it almost like a specialized docket. But ejectment, the older, more general lawsuit to recover possession of real property, sometimes becomes necessary when nobody can agree whether this was ever a tenancy at all. The practical takeaway: don't assume your cousin's story about how it worked in their state is how it works in yours. Pull up your own county court's self-help or landlord-tenant page, or better, call a local attorney before you serve anything. Put these two columns side by side, and the right-hand one is a list of the exact things that feel most satisfying in the moment. And every single one of them is illegal in most states, no matter how clearly you're in the right. Changing the locks, hauling their stuff to the curb, cutting the power to force them out, even just showing up with a few guys to have a talk. All self-help, all illegal almost everywhere. And the cruel irony is that doing any of this doesn't just fail to remove the squatter faster, it can actively hand them a case. Wrongful eviction lawsuits, statutory damages, sometimes criminal charges against you, are all real exposure most homeowners never see coming. The left column looks slower, and it is, but it's the version where you stay the plaintiff instead of becoming the defendant. Let's put real teeth on it's illegal, because the vague version doesn't land. If you lock someone out illegally, they can sue you, and in a lot of states that's not just give my stuff back. It's compensation for a hotel stay, ruined food from a utility shutoff, in some states a multiple of their actual damages, plus you're having to pay their attorney's fees. On top of the civil exposure, several states, New York among them, treat an illegal lockout as an actual criminal misdemeanor, meaning a prosecutor, not just an angry occupant, could come after you. And here's the quieter cost. Even if nothing above happens, jumping the process can taint your own case going forward, because now a judge is looking at a homeowner who broke the law trying to solve a problem the law already had an answer for. Slow and legal beats fast and illegal almost every time here. Here's the long game risk that has nothing to do with this week and everything to do with why you shouldn't just let a squatter situation sit. Every state has some version of adverse possession, a path where someone occupying land long enough, openly and continuously, can eventually claim legal title to your property. California's version is a genuinely useful example because of how specific it is. Occupy the land continuously for 5 straight years, and pay every dollar of property tax on it for that whole stretch, and there can be a real claim. That tax requirement alone defeats most attempts, worth knowing so you don't panic over one summer of neglect. Other states don't require the tax piece and instead just need 7, 10, even 20 years of open, continuous, uninterrupted occupancy. None of that is fast, but not fast isn't the same as never. And every month you let a known squatter sit undisturbed with no police report and no notice on file is a month working against you, not for you. Report it, document it, start the process. Don't just wait and hope they leave. This is one of the fastest moving corners of homeowner law right now, so treat anything you hear as a snapshot, not a permanent rule, and check your own state's current statute before relying on any of this. Florida's the example most people have heard of. Since mid-2024, an owner can file a sworn affidavit directly with the sheriff, and in qualifying cases, skip the courthouse entirely while a deputy goes to remove the person. Georgia passed its own version the same year that lets police serve a formal notice and compress what used to be an 8-month court slog into roughly 2 weeks. And they're not alone. By mid-2025, more than a dozen additional states, including Indiana and Mississippi, had passed their own affidavit-based fast-track laws, some promising removal within 24 to 48 hours for a genuine, no-tenancy claim stranger. But plenty of other states haven't moved at all and still expect the full unlawful detainer or ejectment process we covered earlier. So, "It took my cousin in Florida a week" is not a promise about what happens in your state. Almost every squatter story that turns into a real mess follows the same pattern, and it's rarely about the squatter. It's about what the owner did first. Mistake 1 is waiting, because vacant or unattended property is exactly what squatters look for, and every week of silence is a week their occupancy claim gets a little more established. Mistake 2 is the opposite problem, the angry Saturday move, showing up with a truck and some friends to handle it, which is exactly the self-help trap we just walked through. Mistake 3 is skipping the paperwork trail, so that when you finally do go to court or file that affidavit, you've got nothing but your word against theirs. And mistake 4 is just not checking. A lot of owners assume they're stuck with a slow, expensive court fight when their state may have already passed one of those fast-track affidavit laws we just covered. 5 minutes on your state's official legislature website can save you months. There's a point where this stops being a call the sheriff situation and becomes a call an attorney situation, so know the tripwires. The second the occupant produces any document, a lease, a deed, a bill of sale, even something that looks obviously fake, treat that as a legal dispute now, not a squatter removal, because you may be looking at outright fraud, and fighting a forged document the wrong way can slow you down for months. Same if you file that fast-track affidavit and the sheriff's office denies it or won't act. That usually means your facts don't cleanly fit the statute, and you need someone who can route you to the right court process instead. Get a lawyer immediately if you smell an actual scam. Squatters increasingly show up with a fake deed or a forged sale, and that's a fraud case layered on top of a removal case. And be aware that some circumstances, young children in the household, a disability, a pending emergency, don't change what's legal, but they can change how quickly a court or a sheriff is willing to move, and a local attorney will know how that plays out where you live. So here's what to actually carry out of this. First, the second someone's genuinely occupying your property, your gut reaction, just get them out, has to go through the court, not through you, no matter how obviously right you are. Second, the fastest feeling moves, new locks, cut power, their belongings on the curb, are the ones most likely to turn around and bite you, sometimes literally in court. Third, remember who's actually allowed to do the physical removal. A sheriff or a marshal with a court order, full stop, never the property owner. And last, speed still matters, not to skip the process, but to start it immediately, because documentation and a fast filing are what stand between an annoying situation solved in a month and a years-long adverse possession fight. Handle it that way, and you go from feeling stuck and furious to being the one following a process the law actually built for exactly this. This video is general education, not legal advice, and the rules here notice requirements, unlawful detainer versus ejectment, fast-track affidavit laws, and adverse possession timelines, all vary significantly by your state and by the specific facts of your situation. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and reviewed by a human against the cited sources before publishing. Before you act, check your own state's current landlord, tenant, and property statutes, and if the occupant produces any paperwork, if fraud is possible, or if the sheriff won't act on a fast-track request, talk to a licensed attorney in your state. Subscribe. Homeowner Rights Explained breaks down one homeowner right every video.